Sir, can you show me a video?
Yeah, hello.
Yes. Good afternoon, ladies and gentlemen. It is 1 p.m. Time for the 29th annual general meeting of the company. It is my indeed pleasure to welcome you at the 29th AGM of RR MetalMakers India Limited. Hope you all are safe and healthy. In terms of applicable provisions of the Companies Act 2013 and rules made thereunder, the Act and circulars issued by the Ministry of Corporate Affairs (MCA) vide its General Circular Number 9, 2023, dated September 25, 2023, read with other general circulars regarding holding of the AGM through video conferencing (VC) or other audiovisual means (OAVM), referred to as MCA circulars. The companies are permitted to convene the AGM through VC or OAVM without the physical presence of the members at a common venue. Further, the Securities and Exchange Board of India (SEBI) vide its General Circular Number SEBI HO CFD CFD POD 2 P CIR 2023-167 dated October 7, 2023, read with other circulars regarding additional relaxation in relation to the compliance of the certain provisions of the SEBI listing obligation and disclosure requirement regulation 2015 SEBI circulars. In compliance with the provisions of the Act, the SEBI listing obligation and disclosure requirement regulation 2015 listing regulation, MCA circulars and SEBI circulars, this AGM is convened through VC or OAVM mode. Deemed venue of the AGM is the registered office of the company. Kindly note that the Honorable National Company Law Tribunal, Mumbai Bench NCLT, vide its order dated April 22, 2024, has admitted the application filed by the operational creditor under Section 9 of the Insolvency and Bankruptcy Code 2016, and accordingly the Corporate Insolvency Resolution Process (CRP) was commenced on the company with effect from April 22nd, 2024, and Mr. Vikas Kiani was appointed as an interim resolution professional IRP under the IBC. In this regard, the company has filed an appeal before the Honorable National Company Law Appellate Tribunal, Principal Bench, New Delhi, NCLAT. The appeal was accepted by the NCLAT on April 24, 2024, ordering that no further steps shall be taken in the CRP initiated against the company. Pursuant to order of NCLT till the next date of hearing, the said order of NCLAT is still effective as on date. As per the articles of the company, the chairman of the board shall be entitled to take the chairs at every general meeting. Mr. Virat Sir, the chairman, is present. However, since the company is under CRP, Mr. Vikas Kiani, the IRP, will preside over the meeting and start the proceeding of the meeting. Vikas sir, can you please on your video?
Thank you, Mr. Ripin. Actually, I don't know, my video is on, but I don't know why the video is not working. So no worry, I will start. So thank you and good afternoon, dear members. It gives me enormous pleasure to welcome you all at this 29th annual general meeting of our company. The required quorum being present, I call the meeting to be in order. Further, in terms of the aforesaid MA circulars and SEBI circular, since this AGM is being conducted through VC, there is no requirement of appointment of proxies. Now I request Mr. Vipin Mehta, practicing company secretary, assisting me in conducting the meeting, to take forward the proceeding of the meeting. Over to you.
Thank you, sir. The company has appointed Central Depository Services India Limited (CDSL) for using their platform for remote e-voting facility. The participation at this AGM through VC facility, remote e-voting and e-voting during this AGM. The IRP has confirmed that all the possible efforts to enable the members to participate and vote on the items being considered in the AGM, and the company has complied with all the applicable provisions of the Companies Act 2013, listing regulations, and relevant circular issued by MCA and SEBI relating to convening the AGM through VC mode. The members will be able to attend the AGM with their login credential and as per the procedure stated in the notice of the AGM at page numbers 22 to 24. Participation of members through VC will be reckoned for the purpose of quorum for the AGM as per section 103 of the Act and MCA circulars. Please note that Mr. Madhukar Chavan, statutory auditors, and Mr. Himanshu Kapada, secretarial auditors, are present at the AGM. Please note that the remote e-voting period commenced at 9 a.m. on Wednesday, September 25, 2024, and same has ended at 5 p.m. on Friday, September 27, 2024. The cutoff date for the purpose of remote e-voting and voting at the AGM was Saturday, September 21, 2024. In terms of MCA and SEBI circulars, the annual report was sent to the shareholders on September 6, 2024 through electronic mode only. Further, the correspondence to AGM notice was sent on September 25, 2024 through electronic mode only. The smooth conduct of AGM and in terms of MCA circulars, the company has provided facility to shareholders to send questions in advance to reach the company's designated email address, that is cs@rrmetalmakers.com, on or before Saturday, September 21, 2024, and the option of speaker shareholders has not been provided. Further, mute mode is activated for all the participants except for the panel members. Kindly note that company has not received any questions from shareholders on or before the last date fixed for the same. To begin with, please note that the statutory registers and other documents, including auditor's report, are open for inspection electronically at request. Since in terms of MCA and SEBI circulars, proxy appointment is not allowed, register of proxy is not available for inspection. Since the notice convening the 29th AGM has already been circulated, we are taking the same as read. Now I request our chairman to please brief the members about the working of the company. Vikas sir.
Thank you, Vipin. Dear members, the meeting is called for compliance purpose only. The detailed working and the results of the company is already with you in the board's report. The said report may be read as a IRP's report. Thank you for your presence here today and for your continued support and association with the company. Now I request Mr. Vipin Mehta to take forward the proceedings of the meeting.
Thank you, sir. As per Section 145 of the Companies Act 2013, read with clause 13.2 of the Secretarial Standard 2, the qualification, reservation or comment in the audit report, if any, shall be read out at the general meeting. There was no qualification or reservations given in the auditor's report. However, the auditors in its reports has drawn attention to emphasis of matters. I will read the same and the management reply to the same given in the board report at point number 14A at page number 41 of the annual report. Now the content of the auditor's report. Debtors amounting to rupees 7.58 lakhs are older for a period of more than 3 years on which impairment loss is not recognized by the management based on the lifetime expected credit losses using provisions metrics as per provisions of Index 109 financial instruments. The management of the company has filed recovery suits against the said parties. Refer note 4B, trade receivable of the financial statement. Now the management reply. The company is pursuing to get all its old debtors to recover and is confident to receive the maximum amount. In this financial year, we have already started receiving some amount. Hence, impairment loss is not recognized by the management as per provisions of Index 109 financial instrument. Pursuant to Section 145 of the Companies Act 113, read with clause 13.2 of the Secretarial Standard 2, if the secretarial auditors have mentioned any qualification, observations or comment or other remark in the secretarial audit report, then the same is required to be read out. As the secretarial auditor's report issued by Mr. Himanshu Kapada and Associate contains observation, I will read the observations given in the secretarial auditor's report and management reply for the same given in the board's report at point number 14B at page number 41 of the annual report. The first is, as per the General Circular number 14 of 2020 dated April 8, 2020 issued by Ministry of Corporate Affairs as per point number 3A sub point 11 states that if the annual general meeting held through VC or OAVM, then at least one independent director where the company is required to appoint one and the auditor or his authorized representative who is qualified to be auditor shall attend such meeting through VC or OAVM, but the statutory auditor, his authorized representative, has not attended the 28th AGM of the company. The management replied, due to technical issue, the statutory auditors of the company was not able to attend the 20th annual general meeting of the company. Point number two, the company has filed multiple e-forms under the Companies Act 2013 during the audit period. However, in the majority of the forms, at the signing part, resolution number was mentioned XX in place of actual resolution number by which board of directors authorized the authorized person to sign and submit the form. The management replied, it was done erroneously while filing the form. The company has addressed this mistake while filing the forms in the current year. Third point, the company has approved remuneration of Mr. Naveen Mehta DIN 00764424 in the 26th annual general meeting of the company held on August 13, 2021 for a period of 5 years with effect from December 26, 2020 to December 25, 2025. However, while taking the shareholder approval, details required to be disclosed in the notice of the annual general meeting as per Schedule 5 of the Act was not disclosed. Hence, the payment of remuneration during the period from April 1, 2023 to December 25, 2023 was not in compliance with the Schedule 5 of the Act. The share disclosure was missed to be disclosed. Now the company is disclosing the information in current year notice while taking approval for appointment of manager person and payment of remuneration. Point 4. As per the General Circular number 20 of 2020 dated May 5, 2020, issued by the Ministry of Corporate Affairs, the company can hold the annual general meeting through video conferencing, VC or other audiovisual means OAVM, subject to fulfillment of the certain requirement. As per the point number A4 of the said circular, before sending the notice and copies of the financial statement, etc., public notice by way of advertisement be published containing the information as mentioned in the circular under point number A4, A to G, at least one in a vernacular newspaper in the principal vernacular language and at least once in a English language in an English newspaper, but the company has not published on public notice as per said circular for 20th AGM. The management reply, it was skipped to be published due to oversight. The company will be carefully complied in future in this regard. Point number 5. As per BSc circular number LIST backslash COMP backslash 05 backslash 2019 hyphen 20 dated April 11, 2019, read with the applicability criteria prescribed under the SEBI circular number SEBI HODDHS CIRP 2018 14 4 dated November 26, 2018, the company was required to submit annual disclosure for non-applicability of large corporate criteria within 45 days from the end of the financial year during the audit period. The company has not submitted the said annual disclosure for the financial year ended March 31, 2023. Management replied the same was not submitted as in the previous year. The company has filed initial disclosure of the non-applicability of large disclosures. Hence, the company was of the view that since initial disclosure was not applicable, continued disclosure is also not required to be given. The said requirement was brought to notice of the company in the current year, hence the company has submitted the said disclosure for FY 23-24 in time. 6 point, as per regulation 74(5) of the SEBI Depositories and Participant Regulation 2018, the company has to submit to the stock exchange certificate receipt from registrar and share transfer agent within 15 days from the end of the each quarter. However, the company has submitted the share certificate for the quarter ended December 31st, 2023 to BSE Limited on January 16, 2024, that is with a delay of 1 day. Management report. The company has tried to submit certificate receipt from registrar and transfer agent on last day, but due to some technical problem, the company was not successful. However, the company has submitted the same on next day with the delay of 1 day. Point number 7. As per the regulation 30 of the SEBI listing obligation and disclosure requirement regulations 2015, the company has to submit certain information in prescribed time as given in the said regulation. However, the company has submitted the following information documents to the stock exchange, but the same was submitted beyond the prescribed time as per the said regulation. First is proceeding of the 28th annual general meeting on September 29, 2023 was submitted after 12 hours from the conclusion of said meeting. 2. Newspaper advertisement cutting of unaudited financial results for the quarter ended on June 30, 2023 was filed after 24 hours from its publication. Third, public notice published in the newspaper for 28th annual general meeting of the company was filed after 24 hours from its publication. 4. PDF of quarterly financial results for the quarter ended on September 30, 2023 was filed with the delay of 8 minutes. 5. Letters sent to shareholders holding share in physical mode to furnish PAN, KYC and nomination details on May 19, 2023 was filed after 24 hours from the date of dispatch to shareholders. 6. Intimation for alteration in object clause of memorandum of association was filed after 24 hours after approval was received for amendment. The management reply. Company has complied with and disclosed all the information as required under Regulation 30 of the SEBI Listing Obligation and Disclosure Requirement Regulations 115 in time to stock exchange. However, in certain cases, as observed by the secretary auditors, the company has not submitted the information in prescribed time due to some unavoidable situations, but the same was submitted by the company to stock exchange after due time. The company is implementing systems for timely disclosure in future. Now, point number 8. As per para 1.2.5 of the Secretary Standard 2 and Regulation 36(3) of the SEBI LODR Regulation 2015, notice of annual general meeting should contain the specified details about the director appointment or reappointment. However, the company has disclosed about the information for reappointment Mr. Virat Shah, who was retired by rotation and being eligible, offered himself for reappointment at the 28th annual general meeting, but all the details are not covered as required under the Secretary Standard 2 and Regulation 36(3) of the SEBI LODR Regulation 115, that is committee membership, last remuneration drawn, remuneration to be drawn after appointment, terms and conditions of appointment, relationship with the directors, manager or other KMPs, number of meetings of the board attended during the year. The management replied, the company has disclosed the information as required under Secretary Standard 2 and Regulation 36(3) of the SEBI LODR Regulation 115 for reappointment of Mr. Virat Shah, but few details are skipped to be disclosed in the notice of AGM, but same were disclosed in other parts of the annual report. Company will be disclosing all the information as part of notice of general meeting in future. 9 number. Constitution of Audit Committee was provided in the board report of the company for the year financial year 22-23 as Mr. Alok Shah as the chairman and Mr. Jas Ganatra and Samir Patel as members. Whereas in the corporate governance report, Constitution of Audit Committee was provided as Mr. Samir Patel as the chairman and Mr. Alok Shah and Mr. Jas Ganatra as members. Management reply. Company was mistakenly disclosed Mr. Alok Shah as a chairman and Mr. Samir Patil as a member of the audit committee in the board report, but the corporate governance report correctly disclosed the constitution of audit committee wherein Mr. Samir Patil was mentioned as chairman and Mr. Alok Shah as member. 10 number. As per Rule 8 of the Companies Accounts Rule 2014, the board report of the company shall contain the information and details about energy conservation, technology absorption, and foreign exchange earnings and outgo. The company has provided the details in the board report for the year 22-23 but did not cover all the information and details as required under said rules. Management reply. The company has disclosed the details about energy conservation, technology absorption and foreign exchange earning and outgo in the board report, but the same was not given point wise as provided in the rule, but there was no material information was skipped to be disclosed. Company will be disclosing all the information as required under the rule in the board report for the year 23-24. Point number 11. In the annual report for the year 22-23, designation of Mr. Naveen Mehta, wherever he has signed, was mentioned as director, but he is holding the position of whole-time director of the company. Management reply. Mr. Naveen Mehta signed the annual report of the company in the capacity of whole-time director of the company, but erroneously his designation was mentioned as director while preparing the annual report to be sent to the shareholders. Point number 12. The board report for the year 22-23 prepared by the company for the financial 22-23 contain disclosure as per section 134 of the Companies Act and relevant rules made under the Act. However, the company has not covered the below mentioned points in the said board report. The first point is change in nature of business, if any. Management reply, as there was no change in the nature of the business of the company, the same was not disclosed. Details of subsidiary, joint venture, and associate company. Management replies the company was not having subsidiary, joint venture, associate company. It was not disclosed. Third, compliance of sectoral standard. Due to oversight, it was skipped to be disclosed. Fourth, issue of equity shares with differential voting rights as, as to dividend voting and otherwise. Management replies the company has not issued equity shares with differential voting right as to dividend voting or otherwise. Hence, it is not disclosed. Issue of shares including sweat equity shares to employee of the company. Management realized there was no issue of shares including sweat equity shares to employees of the company. F. Voting rights which are not directly exercised by the employees if in respect of shares for the subscription purchase of which loan was given by the company. Management replied the company has not given any loan to employees for purchase or share subscription of the shares of the company, hence it was not disclosed. G. Details of payment of remuneration or commission to managing director or whole-time director of the company from any of its subsidiary. Management replied it has not disclosed as company did not has any subsidiary during the reporting period. H. As per section 178(4) Nomination and Remuneration Committee policy shall be placed on the website of the company if any, and the salient features of the policy and changes therein, if any, along with the web address of the company at which the said policy was uploaded, shall be disclosed in the board report. The company has placed the Nomination and Remuneration Committee policy on the website of the company, but the web address of the policy was not disclosed in the board report. Management reply. Company has provided salient features of the Nomination and Remuneration policy in the board report, but skipped to provide the web link of the nomination and remuneration policy in the board report, even though the said policy was placed on the website of the company. I. As per section 197, subsection 12 of the Companies Act 2013, read with Rule 5, Sub Rule 1 of the Company's Appointment and Managerial Personnel Remuneration of Managerial Personnel Rule. The company shall disclose in the board report the ratio of the remuneration of each director to the median employee's remuneration and such other details, but the company has not disclosed the details as required under the Companies Act 113. Management reply. Due to oversight, it was skipped to be disclosed. J. As per Rule 5.2 of the Company's Appointment and Remuneration of Managerial Personnel Rules 2014, the company shall include a statement showing the names of the top 10 employees in terms of remuneration drawn in the board report, but the same was not disclosed. Management reply. The reason for non-disclosure was given on the page number 22 in the board report for the year 22-23 in the point disclosure relating to remuneration of directors, key managerial personnel and particulars of employees. K. As per Rule 8 of the Company's Accounts Rule 2014, the company shall disclose whether the company has maintained the cost record as specified by the central government under subsection 1 of section 148 of the Companies Act 113 or not. The company has disclosed about the applicability of the cost audit in the board report but not disclosed about the cost record. Management reply. Due to oversight, instead of commenting on the cost record, comments on the cost audit was made. L. As per Regulation 34 2 subclause E, read with Schedule 5, Clause B of the Securities Exchange Board of India Listing Obligation and Disclosure Requirement Regulation 2015, the company should provide management discussion and analysis report as part of the director's report and include a point which is mentioned in the Schedule 5. The company has provided the said report as part of the board's report, but the said report did not cover the points in the said report. Points are segment wise or product wise performance. Second, discussion on financial performance with respect to operational performance. Third, material development in human resources, industrial relation front, including number of people employed. Fourth, details of significant changes, that is change of 25% or more as compared to the immediately preceding financial and key financial ratios along with the detailed explanation thereof. And details of any change in the return of net worth as compared to the immediately preceding previous financial year along with a detailed explanation thereof. Management reply. The company has provided the management discussion and analysis report which was a part of the board report. However, certain points required by law were skipped to be included in the said report. The company will ensure that the future reports under the said regulation cover all the information required. Since the company has provided remote e-voting facility to all the members of the company, voting by show of hands is not permissible, and therefore it is obligatory for the company to provide similar and equal voting rights to the members who are present at this AGM and not voted through remote e-voting. I will read all the agenda items as stated in the AGM notice. The company has not received any question from shareholders on the designated email ID before the last date fixed for the same. Now I move to the agenda of the meeting. The first agenda is to adopt the standalone audited financial statement for the financial year ended on March 31st, 2024 and the reports of the board and auditors thereon. Since the same have already been circulated, will be taken as read. As informed through corrigendum notice dated September 25, 2024, the company has taken steps and anticipating with the withdrawal of CRP. However, due to paucity of time and matter could not be taken up by NCLT. In view of the above, agenda numbers 2 to 6 of the notice of 29th AGM is stand withdrawn, become infructuous as the CRP continued and the board stand suspended. Hence, the agenda items number 2 to 6 of the 29th AGM would not be taken. The seventh and the last agenda given in the notice of AGM is to pass an ordinary resolution to consider approval for related party transaction with RKB Global Limited. Since all the agenda has been transacted, the chairman will order an e-poll, e-voting for all the resolutions and invite those members who have not voted through remote e-voting for e-voting. Detailed procedure for e-voting at AGM is stated at AGM notice at page number 20 onwards of the annual report. For e-voting during the AGM, please go to the page from where you have joined this meeting to VC and no separate login is required for the same. and click on company's EVSN, that is 240906106, to vote. Once shareholders click on the same, it will take them to the resolution page. Please follow the instructions to vote on the resolution. Facility to cast vote through voting at AGM will be activated once the poll is announced by the chairman. As per Secretarial Standard 2, Para 7.1, in case of remote e-voting, voting commences before the AGM. Hence, proposing and seconding of the resolutions is not possible at the AGM. Therefore, proposing seconding of the resolution is not made applicable at this AGM. Because
Thank you, Vipin. Thank you, Vipin. Since all the agenda items included in the notice of 29th AGM as amended by the corrigendum notice dated September 25th and 2024, which are e-voted and being voted at the AGM, are transacted in view of the provision 008 relevant rules, I now order for a poll for resolutions mentioned at item number 1 and 7. Since voting by show and
sir, your voice is breaking.
voted remote e-voting can't vote on e-poll at this AGM. Voting shall be in proportion to the shares held by the members as on cutoff date. I am appointing Mr. Vipin Mehta, practicing company secretary, partner of VPP and Associates, as the scrutinizer to conduct the poll process in a fair and transparent manner. E-poll will be taken at this AGM immediately after conclusion of the meeting. Voting facility will be available for 15 minutes after. I thank you all for attending the meeting and for your continued support and trust in our local.
Sir, your voice.
Vipin, over to you.
Sir, kindly declare the meeting as concluded.
Mr. Vipin, can we end the meeting now?
Just a minute. Sir, can you please announce the conclusion of the meeting?
Yes,
Sir. Sir, can you announce the conclusion of the meeting?
yeah, meeting is you have to allow the announce the conclusion. I have concluded the meeting.
Thank you, sir. I sincerely express my thanks to all the present for their cooperation in transacting the proceeding of the meeting and sparing their valuable time for attending the meeting. On behalf of the company, I propose hearty vote of thanks to Mr. Vikas Kiani, chairman of the meeting. I also thank all the members for showing interest in the company. I request members to please cast their vote if not voted through remote e-voting. The combined results of the remote e-voting and e-poll at this AGM along with the scrutinizer's report will be available under the Investor Relation tab, Investor and AGM information reports on the company's website at www.rrmetalmakers.com and on the website of the CDCL, that is www.evotingindia.com. Company shall also simultaneously forward the result to BSE Limited where the shares of the company are listed within 48 hours from the conclusion of the meeting. Thank you. I request CDCL to please start the voting.
Yeah, voting will parallelly start. So
Yeah.
can we end this session? Or,
Yeah, please.
Okay. Yeah. Thank you, everyone.
Thank you,
We are
everyone,
just
to
about
attending.
closing the meeting. Yeah. Host, please end the meeting.